Hi, this is Walter Wilson again. Welcome back. Today I want to tell you a little story. And it's an actual case, but I've taken the names off of the narrative to preserve the confidentiality of the relationship I have with the client. But the client authorized me to tell the story. Now the story is that the client was on autopilot. Absolute autopilot. Now, the quickest way to see if you're on autopilot is, number one, look at the tax return you filed with the IRS. In the front, there's a page, and it shows the prior year and the current year. Now, if they say the same thing, basically the same numbers, income, tax, you're on autopilot. Now, the second way to determine if you're on autopilot is look at all the estate planning documents you did when you did them. I would venture to say they're probably old. They're probably 8 to 10 years old. So what you intended to do 8 to 10 years ago, time marches on. Time doesn't stay still. And so your asset base has grown. Maybe the people you used aren't in your world anymore for whatever reason. Maybe that you want to change things. Some things you can change, some things you can't. But in all likelihood, all the stuff you did 8 to 10 years ago hasn't been touched since then. And I would venture to say that here's a classic example. Family sets up what's called a family trust or a revocable trust to avoid the probate process. And it does a great job. But the problem is there's nothing in it. They meant to put stuff in it, but the only thing that the document says is all they put in it was $10. No bank account, no nothing, $10. Well, we don't make a $10 bill, so there might have had been 2 $5 bills. I don't know. I mean, the $10 bill, but then we do make a $10 bill. So, yeah, so maybe there's a $10 bill attached to it, or $5 or 10 ones, I don't know. But normally what I see is nothing's in it. So you end up having to go through probate. Nothing's in it. Well, the same thing goes for the rest of the stuff. So what I see is old and cold documents. I've even seen situations where they weren't even signed. Well, I got a guy that had a revocable trust to avoid probate. His house wasn't in it. His investments weren't in it. Nothing was in it. But he thought that was all he had to do. Had a pour-over will. Wins the lottery. True case. $50 million. He and his wife, happy, bought a boat sailing around, and they get into an accident and they both die. With the only thing they got is a revocable trust to avoid probate. They both die. Well, the exemption equivalents in those days were 10 million each, so 20 million from 50 million, that left 40 million, and the tax was 20 million bucks. Came right out of the kids' pockets. And where did they get it? Right out of the brokerage account. Totally avoidable. Had they just come in and seen someone like me, they could have saved their kids 20 million bucks. We never know when we're going to become disabled. We never know when we're going to die. We're here on borrowed time anyway. We start dying the minute we're born. But if you're 60 or 70 years old and you haven't done anything, the Reaper is waiting. And the Reaper always wins. It's through the inaction of you that's going to clearly affect them. And normally you don't even include them in the process. But remember, it's an entirely voluntary tax. You choose whether they pay it, when they pay it, and how much they pay. That's your job. So go do your job now and save those kids a ton of money. Oh, and one other thing. I said this in a prior session. You got to bring them into the process. Because if they're married, you don't want the legacy, in this case, 50 million bucks, going to a divorce. Zero problem if you're proactive. So I hope you give us a call, or if not me and my team, give someone that you trust a call. You need to look at this now. Thanks a lot.